Both applicant and respondent are each allocated a total of 45 minutes to deliver their arguments. The 45 minutes shall cover the pleadings of the first and second oralist, and including the rebuttals and surrebuttals. The applicant begins first with their main pleadings, followed by respondent. Afterwards, applicant will once again deliver its rebuttal and followed by respondent's surrebuttal. The judges are allowed to ask questions during the entirety of the oral pleadings.
Mr. President, Your Excellencies, may it please the Court.
The second issue is whether Ravinia violated international law on jurisdiction and immunity by prosecuting Ms. Cross. At the time of the enforced disappearances, Ms. Cross was Ambrosia's Minister of Interior, acting under the ILSA program. While kidnapping is criminalized in Ambrosia, enforced disappearance is criminalized in Ravinia. Both states are parties to the ICPPED, which provides mechanisms on extradition and prosecution. Despite Ambrosia's extradition request, Ravinia arrested and prosecuted Ms. Cross while she was residing in Ravinia's territory. First question is universal jurisdiction. Ambrosia argues Ravinia cannot prosecute since Ambrosia requested extradition and is willing to prosecute. Ravinia counters that under the ICPPED, it may either prosecute or extradite, and it chose to prosecute, doubting Ambrosia's credibility. The second question is on immunity. Ambrosia claims that Ms. Cross enjoys functional immunity as Minister of Interior. Ravinia argues that enforced disappearances are not official acts, therefore immunity does not apply.
Each applicant and respondent must present their case before the International Court of Justice. 9 matches await in this round. Each one a battle of wit, skill, and strategy in international law. Who will present the stronger case? Who will convince the court? The stage is set. Up first before the International Court of Justice, the applicant, University of San Agustin, versus the respondent, Emilio Aguinaldo College, Cavite. Now, applicant begins with its submissions.
Universal jurisdiction, as provided for by the former ILC President, Mr. Christian Tomashat, has noted that it is the power of a state to prosecute an offender for an offense regardless of where it is committed and regardless of the nationalities of the victims or the offender.
But in cases of torture, enforced disappearance, you now have a convention for it. Is there not an obligation on the part of states to prosecute?
We do agree with that, Mr. President, and we also agree with the object and purpose of these conventions, which is to combat impunity. But we note, Your Excellencies, that the inclusion of universal jurisdiction in these same conventions is also dependent on whether the holding state must exercise such jurisdiction by the requisite competence or by the requisite further obligations to the same conventions. Now, we note that Christian Tomashat has substantiated the very definition of universal jurisdiction, but he further notes in his commentaries that it is to be exercised as a jurisdiction of last resort. This was also supported by judges, former ICJ judges, Kujimans, Bergenthal, and Higgins in their separate opinion in the arrest warrant case of this court, which stated that universal jurisdiction does not exist as a pure custom, but is dependent upon the rules of international law. Finally, we call upon the SS Lotus case of the Permanent Court, which states that regardless of the rules pertaining to jurisdiction, they exist for the very purpose of providing limits to when states may exercise that same criminal jurisdiction.
After we heard the applicant's arguments, now it's time to hear what the respondent has to say.
Good afternoon, Your Excellencies, Mr. President. Alleged abductions where Cross was being implicated constitutes a crime of enforced their disappearance, which is defined in international law, a crime against humanity. Enforced disappearance is a serious crime and a violation of human rights. It involves a multifaceted type of violation of fundamental human rights, in particular the right of life, liberty, and security of persons.
So you're saying that under the Convention on Enforced Disappearance, you have an obligation to prosecute under universal jurisdiction cases of enforced disappearance.
Yes, Mr. President.
And under that statute, there's a requirement to extradite or to request extradition.
But in this case, Mr. President, Ms. Cross is already in Ravinia. And having to extradite Ms. Cross back to Ambrosia makes it pointless for it to be done, since in Ravinia, we could already prosecute her for the crimes that she has been found or being accused of. The convention.
Let's go to her immunity. Why should she not be considered as having functional immunity?
The reason, Mr. President, for her not to be having functional immunity was because this was outside of her scope already. This is not within her scope as the Interior Minister of Ambrosia.
That's it?
Yes, Mr. President.
That's it. Ultra-virus acts.
Yes. Yes, Mr. President.
But isn't that a question of international law then? That there are, whether her acts are within the scope of her duties or ultra vires? And therefore, this body has jurisdiction over?
I would agree, Mr. President, but for this specific case, I would say that Ms. Cross need not to be prosecuted by the said court, since it already falls under the jurisdiction of Ravinia itself. Even though it is not done by our officials, still it falls under the jurisdiction, since Ms. Cross is in Ravinia. The fact still remains that Mrs. Cross is still in Ravinia, and having to extradite her outside of it is just another procedure that prolongs justice from being upheld.
Are there standards that are recognized internationally for an act to be performed in an official capacity?
Yes, Mr. President. Apologies, Mr. President. I don't have the answer to that right now.
Next, the applicant, Mindanao State University, taking on the respondent, San Beda College, Alabang.
I think she's being charged under a domestic law. She's not being charged with enforced disappearance under international law.
However, Your Excellencies, we humbly submit that such domestic legislation is also sourced from that treaty entered into Ravinia and Ambrosia, of which there are also state parties and signatories.
So you're saying that they cannot have a law based on a treaty, in which case so many different countries will be in violation of that principle?
Your Excellencies, applicant humbly submits that if ever enforced disappearance happened, we humbly submit, Your Excellencies, that the requisites that would prescribe the crime of enforced disappearance are not met. Hence, Ravinia cannot tenably invoke jurisdiction, since its assertion of jurisdiction over Ms. Gertrude Cross would be unlawful absent the crime of enforced disappearance, since Ms. Gertrude Cross is immune as an Interior Minister.
Why is she immune?
Your Excellency, Ms. Gertrude Cross, as an Interior Minister, which is a high-ranking official has immunity ratione personae and immunity ratione materiae under international law. Immunity ratione materiae applies even though the official leaves office because such is attached to the function of his office and not of his personal acts.
After we heard the applicant's arguments, now it's time to hear what the respondent has to say.
Assuming that, yes, it's a continuing violation, etc., etc., wouldn't it be more practical that the case be heard in Ambrosia, considering that all evidence, all witnesses are based in Ambrosia?
Actually, we respectfully submit for a second submission that there is no violation of international law by asserting our criminal jurisdiction over former Minister Cross, given that the entire principle of aut dedere, aut judicare, or the obligation to prosecute, as held in the case of Eichmann versus Israel, Demian Vuk versus Petrovsky, as well as Belgium versus Senegal.
Agent, you agreed in an extradition treaty to actually give Mrs. Cross to Ambrosia in case they request. Why wouldn't you do that?
You have to see, we respectfully submit that we do not have an obligation to extradite Minister Cross, given that in determining the obligation to prosecute and extradite under paragraph 95 of the case of Belgium versus Senegal, this honorable court ruled that first, the primary obligation is to prosecute, and extradition is only an obligation available when the state is unable or unwilling to prosecute such person. And second, Your Excellency, that the existence of the extradition treaty does not conflict with the ruling of Belgium versus Senegal, given that in this case, under clarification number 6 of the Statement of Agreed Facts, the extradition treaty is for the purposes of punishment, trial, and investigation, given that our state is more than willing to do all of these things in connection with Article 14 of the ICPPED, which provides that member state...
Wouldn't it be more practical that she be prosecuted in applicant state?
Excellency, respectfully, would also further submit that it would not be practical to extradite Minister Cross to the Union of Ambrosia, given that the facts would show that while her investigation was ongoing at the very first instance, she already moved to the Republic of Romania even before the investigation was closed. And secondly, Your Excellency, the investigations were only open due to public pressure by virtue of the statements and protests by the Blackwood detainees.
Next before the court, the applicant, San Sebastian College, Recoletos, Manila, against the respondent, Ateneo de Davao University.
Madam President, Your Excellencies, universal jurisdiction exists to combat impunity, not to create an international spectacle. The case concerning the former Minister Cross bears a striking resemblance of Rwanda and Belgium, which served as a grim reminder of what happens when foreign courts fail to grasp the full weight of a crime. When justice is distorted by a distance detached from the voices of those who have suffered.
Agent,
Yes,
can you demonstrate why are you now attacking the courts that heard the Rwandan genocide? Is that what you're saying now?
Madam President, I appreciate the compelling point in that matter.
Is that what you're arguing?
No, Madam President. This is regarding the case of Sister Gertrude from
Yes.
Rwanda.
And how is that statement even relevant to this?
This is one of the earliest transnational crimes that were prosecuted in a different state, Madam President.
So,
there was a lack of serving of justice, Madam President, because the courts who prosecuted the Sister Gertrude back then do not have the capability of appreciating the facts.
are you now saying the court that prosecuted the Rwandan genocide doesn't have the capability nor the appreciation of the situation?
Yeah, and you cited distance as one factor. So what we are trying to ask is, are you saying that that case is now applicable or not applicable to the case at hand? Why are you citing that case?
We relate this case with regards to the the state of Ambrosia. It may be small and it may be sinking, but it remains a sovereign state, unlike what happened in the case of Sister Gertrude from Rwanda, where she has to be prosecuted somewhere else. Ambrosia, although they have conflicts, internal conflicts within them, it remains a sovereign state. Its vast coastlines bring a complexity to this case that warrants international scrutiny, but not at the cost of eroding its right to self-determination. The question before us is not merely legal, it is foundational.
After we heard the applicant's arguments, now it's time to hear what the respondent has to say.
Are you now saying that your domestic law actually has provides for universal jurisdiction?
Yes, Your Excellency.
On
It
what
was
ground?
provided in the definition under the 2007 Romanian Criminal Code.
Yes, on what ground? Why is there universal jurisdiction for this particular
There is
type of...
universal jurisdiction, Your Excellency, because of the nature of the crime of cross, which is enforced disappearance, which is defined to be a crime against humanity. It is stated that the prohibition of enforced disappearance is considered to be a jus cogens norm that
Okay,
would warrant...
there's no doubt about it. But my question is, now that the other state to whom this alleged offender, is a national, there's a request for extradition because they want to prosecute. Why is there resistance?
Your Excellencies, if you can refer to paragraph 5 of the corrections and clarifications, it is stated in the extradition treaty that the parties undertook to extradite persons who are alleged of specified offenses for their trial and prosecution. Nowhere in that extradition treaty was a mandatory language incorporated that would insist on the obligation to extradite. Also, it was stated in the case of Belgium versus Senegal that which interpreted the...
Wait, so are you now saying that an agreement should indicate that you have no choice but to extradite? So
No.
it's optional. So why create an agreement if it's optional?
No, Your Excellency, it's more of the wording of while the wording itself does not provide for a mandatory nature, that obligation to extradite or prosecute was also interpreted as an option in the case of Belgium versus Senegal.
Again, sorry, how is it applicable? Can you demonstrate?
In this particular instance, Your Excellency, our choice to prosecute is first based on the ICPPED. If we are going to weigh the options of extradition or prosecution as interpreted in the case of Belgium versus Senegal, this honorable court has ruled there that these are alternative manners or alternative ways to combat impunity, such that extradition would
Yes,
be...
but they clearly want to prosecute. So why the resistance?
Your Excellency, it bears noting that they already had an opportunity
Yes,
to
but
prosecute cross.
At that time, it was a different, scenario. Now you have the president back and clearly expressed the intent to prosecute. So why are you resisting?
Your Excellency, it was mentioned in paragraph 50 of the compromise that at the time that the Prosecutor General had investigated the first investigation, they already had access to the evidence citing the alleged involvement of Cross. Your Excellency, we are providing that Ravinia would constitute a more impartial tribunal when it comes to the prosecution.
But would you have access to all the witnesses necessary?
Your Excellencies, while that may be a concern, it also bears noting that Cross is currently in our
Yes,
domestic
but the
territory.
witnesses.
Yes, Your Excellency.
It's only Cross within your jurisdiction.
Your Excellency, while that may be a concern, the extradition of Cross would be more prejudicial to the Ambrosian citizens, considering that the crime of enforced disappearance was conducted in their territory, and by virtue of Cross being a former state official, it opens the risk to a political and legal interference. It was stated in the compromise under paragraph 57 that Prosper Derry himself stated that he had no knowledge of any particular acts or wrongdoings of Cross. Aside from that, the Blackwood victims themselves have expressed their concern with regard to the prosecution of Cross, stating that posing the question that is it because that Cross was a former state official that she is able to evade accountability for her actions?
Exactly. Isn't the fact that the applicant have clearly expressed intent to prosecute thereafter, isn't that a show of sincerity that they are now acting upon the complaints of the former Blackwood detainees and, the previous inability to prosecute her?
Your Excellency, we understand your concern that it may be a show of sincerity. However, it can also be a way to evade accountability with respect to Cross, considering that based on the factual circumstances of the case, it was provided in paragraph 63 that even if there were to be a trial in Ambrosia, Ambrosia would have the right to limit the evidence that would be shown to the public. So,
as with any court.
Yes, Your Excellency. However, given the magnitude of the case, it would be more prudent and more to the interest of the victims who are located in Ambrosia if they are able to access the evidence that are imputed against Cross without prejudice to the rights of Cross as an accused.
The elimination round will continue when the JESSUP 2025 Philippine Round Journey returns. The competition continues. Up next in this round of argument, the applicant, University of San Carlos, facing the respondent, University of San Jose Recoletos. Now, applicant begins with its submissions.
Mr. President, Your Excellencies, good day once again. The gavel must fall in Ambrosia. The ILSA program took root in Ambrosia, so now it must investigate its own Minister of Interior, Gertrude Cross. Applicant comes before this honorable court presenting will it sanction Ravinia's violation of international law on jurisdiction and immunity.
We're talking about facts and acts committed by Ms. Cross as early as 2017 to 2020. So, is it not that this court does not have jurisdiction over this case? Because it happened way back?
Mr. President, while there has been a fact that occurred such as the years 2017 to 2020, it did not necessarily give rise to any dispute, regardless of the fact if Ms. Cross had indeed committed criminal transgressions or the crime of enforced disappearance for that matter. Because we would not be presented before this court or we would not appear before this court if only that Ravinia did not exercise its discretion to arrest and prosecute Ms. Cross. Applicant firmly submits to the negative. The Ravinian courts are not competent to exercise their jurisdiction, lacking the necessary nexus under Article 9, Paragraph 1 of the International Convention for the Protection of All Persons from Enforced Disappearance.
What is that necessary nexus, Agent?
That is the nationality and the passive and active nationality and the territoriality nexus. And in this case, Your Excellency...
Are you saying, Agent, that Ravinia is not allowed to enact criminal statutes with extraterritorial effect?
It can, no, Your Excellency, it can enact criminal statutes, even those that exercise extraterritorial criminal jurisdiction, as this is within the reserved domain of Ravinia. However, the matter before this court no longer falls within the reserved domain of Ravinia for the very fact that the subject of the arrest and prosecution is a foreign former state official in the name of Ms. Cross who was in the exercise of state function and state authority and therefore immune under international law.
After we heard the applicant's arguments, now it's time to hear what the respondent has to say.
Do you contest the characterization of the first applicant that universal jurisdiction has been engaged?
Yes, Your Excellencies, it is our submission that our prosecution over Cross is in the exercise of universal jurisdiction as stipulated under Article 9, Paragraph 2, Your Excellencies. To proceed to our...
So you're invoking your assumption of this case on the concept of universal jurisdiction?
Yes, Your Excellencies. As a matter of fact, the applicant have cited Your
Are
Excellencies.
you aware that universal jurisdiction is not absolute and is only limited for very serious crimes?
It is our position, Your Excellencies, that pursuant
War
to
crimes and crimes against humanity, this is just enforced disappearance.
firstly, Your
It's not
Excellency,
fall within the ambit of crimes of humanity for you to invoke universal jurisdiction.
I understand your concern, Your Excellencies, but firstly, the applicant, Your Excellencies, have already acknowledged that the universal jurisdiction can be invoked for crimes of enforced disappearances, notwithstanding the fact that it is explicitly provided under the ICPPED. And to your concern, Your Excellencies, the universal jurisdiction is not only limited to those serious international crimes or to jus cognos.
Is enforced disappearance covered by this principle of do you have a basis to say that you can acquire jurisdiction in this case?
Yes,
under
Your
this
Excellency.
principle?
Yes, Your Excellencies, we have a legal basis as to our invocation or exercise of universal jurisdiction. Under Article 9, Paragraph 2 of the ICPPED, Your Excellencies, it provides the authority of the states to exercise universal jurisdiction, and the jurisdictional nexus required in order to successfully and validly exercise universal jurisdiction, Your Excellencies, is merely on the part of the alleged perpetrator.
So any state party to the Enforced Disappearance Treaty can exercise jurisdiction in your opinion, right?
Yes, Your Excellencies.
So which one would have priority?
We submit, Your Excellencies, that the state parties under the ICPPD has actually a concurrent jurisdiction.
Up next, the applicant, Far Eastern University Institute of Law versus the respondent, Silliman University.
Mr. President, Your Excellencies, good afternoon, and may it please this honorable court.
Which came first, your request for extradition or the start of the criminal investigation in the respondent?
Your Excellency, the arrest and prosecution by Rovinia started before the investigation. However, the Ambrosian ambassador already asserted the immunity of Cross from foreign criminal jurisdiction, and this is in connection with the ongoing investigation being undertaken by the Ambrosian Prosecutor General. However, Rovinia failed to act upon our extradition request.
But would you agree with me that under the Enforced Disappearance Convention, the respondent has the power and authority to prosecute the ex-minister?
Your Excellency, if I may guide this court back to Article 9 of the ICPED, which provides for the authority of each member state to prosecute an offender who is its own national. And in connection with this...
But Article 10 also authorizes other states to prosecute offenders who are within their jurisdiction, correct? So how do you harmonize the two? Or what's your basis for saying that Article 9 should prevail over Article 10?
Your Excellency, there is no showing that Ambrosia is not capable of undertaking an investigation and prosecution of Cross.
But why is that a requirement?
Your Excellency, this is in pursuance to the dual criminality principle, wherein the offense over which the requesting state bases its request shall also punish the said offenses.
After we heard the applicant's arguments, now it's time to hear what the respondent has to say.
What was the basis for the determination by the Prosecutor General in Rovina to convict Ms.
Your Excellency, to clarify, the Republic of Rovina has not yet convicted Ms. Cross, but rather they are conducting an investigation against Ms. Cross, Your Excellency, under paragraph 61 of the compromise. And it is stated there that although some sources or pieces of evidence were from the HRI report, it is our submission that the Republic of Rovina did not fully rely on these sources since they conducted an independent investigation, Your Excellency.
I have one question. when you speak of international relations, you don't want to strain your relationship, of course, with Ambrosia, correct?
Certainly, Your Excellency.
So, instead of going to us, why don't you just turn her over to Ambrosia?
Your Excellency, we are before this honorable court due to Ambrosia's submission of the dispute, Your Excellency, and we are requesting this court to declare that it lacks jurisdiction, Your Excellency. And in addition to this, Your Excellency, under the ICPPED, there is a procedural requirement of negotiation, and the Union of Ambrosia has failed this procedural step, Your Excellency, and thus we are before this honorable court requesting you humbly to declare that it does not have the requisite jurisdiction does not have the requisite jurisdiction, Your Excellency, to decide on this case.
No, mine is just a simple question. If you want to keep peace within the peninsula, why don't you just turn her over to Ambrosia?
Well, we understand this view, Your Excellency, for the interests of justice and equity, Your Excellency. If we do turn her over to Ambrosia, there is a very high risk and possibility that Ms. Cross be pardoned and that there be no prosecution against her, Your Excellency, since under paragraph 50 of the compromise, the Prosecutor General of Ambrosia already had pieces of evidence that would have been indicted or convicted Ms. Cross. However, they refused to use these pieces of evidence, and thus it is Rovinia's assertion then, Your Excellency, that if she be prosecuted there would be there would be no legal justice, Your Excellency.
Next, before the judges, it's the applicant, Cagayan State University Carig, going head-to-head with the respondent, Bukidnon State University.
Counsel, would you agree that the act of Rovinia in arresting Ms. Cross within its territorial jurisdiction is an act of sovereignty on the part of Rovinia, and as such, acting on its power of sovereignty, it was just implementing its laws against disappearances, and this is within its domestic law and has jurisdiction to do the same. So therefore, the jurisdiction in this case should be with Rovinia and not with this court.
Yes, Your Excellency, while we do acknowledge that Rovinia is just implementing its domestic law, however, Your Excellencies, at the very beginning, they do not have jurisdiction over Ms. Gertrude Cross because as the elements provided by the ICPPD are not present under their jurisdiction, it is in the Ambrosia.
What are these elements that you mentioned?
The elements are as follows, Your Excellencies, that the accused is a national of such certain jurisdiction. The victims are nationals of such certain jurisdiction, and the alleged crimes of enforced disappearances happened in their territory, Your Excellencies. All of those elements, Your Excellencies, are present in Ambrosia's jurisdiction.
But do you have a law that punishes enforced disappearance? Do you have a law that, in the same manner that the respondent has a law that punishes this act?
Yes, Your Excellency. As provided in the record, President DeRay himself stated that we have all the proper tools and mechanisms set in our...
No, I'm asking about the law. Do you have the legal framework to punish this act being brought against Ms. Cross in your jurisdiction?
Your Excellency, while it was not directly provided in the records, however, Rovinia and Ambrosia have entered into a bilateral extradition treaty, and one of the extraditable offenses are enforced disappearances.
After we heard the applicant's arguments, now it's time to hear what the respondent has to say.
Mr. President, Your Excellencies, good afternoon, and may it please this honorable court.
I understand you're invoking already universal jurisdiction, right? But that's premised under the assumption that the applicant didn't request for extradition. Didn't they request extradition of Ms. Cross in this case?
Yes, they did, Your Excellency.
And the truth is you refuse to extradite Ms. Cross, right?
Yes, Your
And that's the
Excellency.
subject matter of the dispute. Thus, we have jurisdiction. Is that correct?
Yes, Your Excellency.
So we have jurisdiction.
My apology for that, Your Excellency. I misheard your question, but we do not submit, Your Excellency, that this honorable court has jurisdiction to try the second submission of Ambrosia, Your Excellency, by virtue of universal jurisdiction, because it falls within the second exception, precluding ipso facto the subject matter jurisdiction of this court, Your Excellency. If I may say, if something is within the domestic jurisdiction of a member state, then it excludes the jurisdiction of this honorable court, Your Excellency.
But the claim of applicant is that your refusal to extradite is unjustified, which constitutes an international dispute. And that falls under the first provision of the compromissory clause and not on the second one.
Your Excellency, while we submit that or we agree that they have requested for extradition, once again, Your Excellency, we are invoking, or we would like to help this court or guide this court by reviewing, Your Excellency, the Hague formula, which is binary selection, Your Excellency, and was decided or mentioned by this honorable court in the case of Belgium versus Senegal. And Your Excellency, we do not agree that it is the first article or the article or the general rule provided under the compromissory clause that has effect on this case, Your Excellency. However, we submit that the second or the paragraph B of Article 21 is where we are rooting, Your Excellency, our argument, because we do believe that by virtue of the Hague formula, we have jurisdiction to hear and try this case because of universal jurisdiction that is granted by Article 9, Paragraph 2 of the ICPPED, Your Excellencies.
The final set of matches is coming up when the JESSUP 2025 Philippine Round Journey returns. The competition continues. Up next, the applicant, University of Makati, taking on the respondent, San Beda College of Law.
Again, good day. May it please the court, I am Ben Harkekegan, the first agent of the Union of Ambrosia.
Sovereign immunity is a matter of international law.
Yes, Your Excellency.
Therefore, this isn't a matter that's exclusively within your state's domestic jurisdiction.
Your Excellency, we respectfully submit that Mr. Kirk Cross has functional immunity.
But that's international law. Whether you have immunity or not, especially in a foreign state, that's a matter of international law.
Yes, Your Excellency. And that is the very reason why we are submitting our submission B for this honorable court to determine that indeed that Mr. Kirk Cross has immunity and Rovenia does not have any jurisdiction over her.
But that contradicts your position now. Because now you're saying that this is entirely, everything is within your state. Therefore you should have sole jurisdiction.
Your Excellency, I would like to clarify that I'm not asserting that we have absolute domestic jurisdiction over this case, but rather I would like to point out that Rovenia does not have exclusive domestic jurisdiction, because that is what they are asserting, Your Excellency. That is why that they do not want this court to have jurisdiction, because they mentioned that the exceptions under the OCDP compromissory clause apply in this case, which we believe on the contrary, Your Excellency.
After we heard the applicant's arguments, now it's time to hear what the respondent has to say.
The acts of Ms. Cross that you are pertaining to happened even before she lived in Rovenia.
Yes, Your Excellency.
So how does that give you jurisdiction?
Because particularly our criminal code provides that a person committing the crime of enforced disappearance can be an agent acting in official capacity. And Ms. Cross at the time acted in her official capacity as Minister of the Interior of Ambrosia when she committed the crime.
Doesn't that imbibe a flavor of international law inside that statement? I mean, you're saying that she did it as an official of another state. And therefore, you have to consider international law in evaluating whether she was a state agent.
Yes, Your Excellency. And on that fact, we use the International Convention on the Protections of Persons Against Enforced Disappearance. Now,
well, in that case, if you're using an international convention, then this isn't purely a matter of municipal law.
Well, yes, Your Excellency, but primarily we use our municipal law to gain jurisdiction over her because she is within our territory and we are authorized to regulate non-nationals within our territory. But Your Excellency is assuming that this court still finds that jurisdiction on that part. We submit that ultimately Rovinia is only acting within its with sovereignty when it arrested Ms. Cross. Particularly, Rovinia exercised police power, an inherent power of sovereignty attributable to any state when it arrested Ms. Cross.
Agent, do you agree that Ms. Cross acted in her official capacity?
At the time she committed the crime, Your Excellencies, yes.
So if she acted in official capacity, then I think what the applicant is saying is that she essentially has functional immunity, and you did not, you disregarded this immunity that was supposed to be accorded to Ms. Cross.
Yes, Your Excellency. And particularly the reason why the respondent state disregarded that statement is because she is no longer an official of that country. She has fled to Rovinia at the time we had charged her. And
but I think that contradicts your statement that you recognize that she did these acts in her official capacity.
during that time, Your Excellencies, yes, we did recognize. But now that she isn't a national, she can be prosecuted. We exercised our jurisdiction over her.
Okay, let's circle back. What is the standard for saying something is entirely within municipal law?
Your Excellencies, there are multiple cases that decide this, and all of them point to two main factors. Firstly, that there is an act committed by a person, and this act is punishable under the local laws of a state, which is present here in this case. These grounds are present here, Your Excellencies. Ms. Cross Ms. Cross entered into Rovinia's sovereign jurisdiction, and upon she entered, and we did not immediately prosecute her. We only prosecuted her upon knowledge of a report conducted against her committing the crime of enforced disappearance. Only then did we exercise jurisdiction.
Next, the applicant, West Visayas State University versus the respondent, Aurora State College of Technology.
If I may direct your attention to paragraph 5 of the clarifications, it provides there that both Ambrosia and Rovinia entered into a bilateral extradition treaty. Moreover, in paragraph 61, it provides that they are both state parties to the VCLP. And in this case, since enforced disappearance is covered by the extradition treaty, there is no legal ground for the respondent to derogate from their obligations under that bilateral extradition treaty.
Agent, what does the domestic law of Ambrosia say about enforced disappearance? Does it punish enforced disappearance?
Your Excellency, currently the Ambrosian law with regards to enforced disappearance, there is no separate and distinct law in Ambrosia. However, Your Excellency, there is the crime of abduction and kidnapping as provided for in the agreed facts. However, since Ambrosia is a state party to the ICP-PED, if the investigation provides that the elements of enforced disappearance is present in the case of Cross, then Ambrosia can always invoke the provisions provided for by the ICP PED in prosecuting Cross.
Thank you very much, Applicant.
After we heard the applicant's arguments, now it's time to hear what the respondent has to say.
How do you define universal jurisdiction?
Your Excellency, the universal jurisdiction is a principle in international law which allows for all the states to take jurisdiction of cases, particularly which are in violation of the fundamental human rights. For example, like the genocide, apartheid, and among other cases, Your Excellencies.
Is there a single globally accepted definition for universal jurisdiction?
There is none, but there is a compelling definition, Your Excellency, provided by the International Laws Association. And in fact, aside from genocide and even this apartheid, Your Excellency, the recent addition was enforced disappearance, Your Excellency. It was in letter E of the International Law Association inclusion when it comes to universal jurisdiction, Your Excellency.
Is its basis treaty or customary international?
Your Excellency, it was primarily a customary law, but it was enacted or codified into a convention, Your Excellency.
Are you familiar with the countries that have signed the treaty on that matter?
Your Excellency, while I'd like to answer, may I request for an additional minute to...
No, you can just summarize your answers now.
Your Excellency, yes. To answer first your question, Your Excellency, the respondent most humbly recognized that there is no specific information as to the number of states, but we humbly submit that the International Law Association, considered as one of the sources of international law in paragraph 38 of the ICJ statute, is sufficient to convince, most respectfully, this court to qualify the enforced disappearance as a customary law. And hence, the universal jurisdiction may be taken in view of this enforced disappearance, Your Excellency.
And finally, for the second issue, the applicant, Ateneo de Manila University, against the respondent, University of San Carlos.
Madam President, Your Excellencies, good day and may it please the Court. Your Excellencies, at the very heart of this case is a choice of whether this Court will allow the respondent to cast aside the very rules that it once agreed to and stretch the limits of international law.
The respondent state precisely wants to exercise universal criminal jurisdiction because perhaps by extraditing Ms. Cross back to your state might not really be that vigorous when it comes to prosecuting one of your own, basically.
Your Excellencies, we do understand that that is what the respondent may claim. But Your Excellencies, according to paragraph 92 of Belgium versus Cignal, there are two conditions that must be met for a state invoking universal jurisdiction to be granted that jurisdiction.
Hasn't your key state officials' public pronouncements basically exonerated her already? Because your president, even the acting president under the Transitional Council basically says she did that in accordance with our anti-criminality policy, etc. So, and before the case goes to court, which is a more neutral venue, it would have to go through your state's prosecutorial arms, which are under the office of the president. So that's why maybe the respondent state's concerns may be valid, extradite, but then your prosecutors will later on say no charges, and then that's it. That's exactly the safe haven that the universal criminal jurisdiction doctrine seeks to avoid, correct?
Your Excellency, yes, that is what the universal jurisdiction seeks to avoid, but that is not what is present in the applicant state, Your Excellencies. First, the President or President De Rey and even Acting President Zavala are independent from the Ambrosian Prosecutor General. And this is proven by the fact that according to paragraph 5 of the clarifications, the Ambrosian Prosecutor General was the one who initiated the investigations on Ms. Cross. Second, Your Excellencies, according to the case of Prosecutor versus Gaddafi, there must be a clear and convincing evidence to prove that state officials are shielding the accused from prosecution. Your Excellencies, we are with the respondent that justice must be pursued, but that justice cannot and must not be pursued at the expense of the equally important principle of state sovereignty.
After we heard the applicant's arguments, now it's time to hear what the respondent has to say.
This court can determine the legality or illegality of the arrest, even without going into whether Ms. Cross did indeed participate in the alleged enforced disappearances under the ELSA program. That's different. That's substantive and procedural law. So how will you contend with that?
Indeed, Your Excellency, while this honorable court may need not look at the involvement of Ms. Cross in determining the validity of the arrest and prosecution, however, applicant's submission earlier, Your Excellencies, revolves on the non-granting of Ravinia of the immunity of Ms. Cross. Your Excellencies, in order to determine whether Ravinia's refusal to grant this immunity, it has to look at whether the involvement of Ms. Cross in the crime of enforced disappearance under the ELSA program was committed in its official capacity. Therefore, Your Excellencies, this honorable court still needs to look at the involvement of Ms. Cross, which predated the entry into force of the compromissory clause on March 17, 2021. Turning now, Your Excellencies, to the discussion on jurisdiction raison et matérielle. Applicant also relied on the advisory opinion of the predecessor of this court in the 1924 nationality decrees issued in Tunis and Morocco. However, Your Excellencies, this cannot be applied in this case, considering that in that advisory opinion, the predecessor of this court used the word solely instead of using the word essentially. While the applicant in their written pleadings provided that there is no material difference between solely and essentially, Your Excellencies, we submit to the contrary, considering that there is already an evolution of under international law. This is evident in the 1945 San Francisco Conference, where states have already agreed and adopted the use of the term essentially from the use of the term solely.
So on the part of the respondent state, what was your obligation from your perspective?
It is our obligation to prosecute Ms. Cross in accordance with our own domestic law, the 2007 Ravinian Criminal Code.
And is that an exclusive obligation, or is there an alternative obligation that you could have used to also be in compliance with your international law duties?
Your Excellency, while we do have an alternative obligation under Article 9, Paragraph 2, which is the obligation to extradite, however, Your Excellencies, these obligations are merely discretionary on the part of Ravinia, and it is for the better interests or best interests of the victims of enforced disappearance to exercise the discretion to prosecute Ms. Cross before the premonition.
So your position is that they are co-equal choices. There's no preference in favor of one over the other.
There is a primary obligation to prosecute, Your Excellency.
Okay. So what's the basis for that? Because the international law obligation is aut dedere aut judicare, right? The dedere is the surrender or the rendition, and the judicare is the prosecution. So is it just a coincidence that the dedere came first before the judicare, or are they actually interchangeable?
Your Excellency, they are indeed interchangeable. However, this honorable court already affirmed in the 2012 Belgium versus Cignal case that the obligation to prosecute is a primary obligation, and that the obligation to extradite is only a mere option. This is also evident in the International Law Commission report in 2014 in aut dedere aut judicare, that under the second formula of aut dedere aut judicare, there is a primary obligation to prosecute, and that the obligation to extradite is merely an option. Your Excellencies, this ends the submissions of the first agent for the respondent. May it please the court.
It's both our first time to join a moot competition ever. So it's kind of nerve-wracking, pero okay naman, kinaya naman. Though there are lapses, I think we did well.
Interruptions and rapid-fire questions from the judges are not new, but with the constant practice, I've learned to manage it in a way that I kind of have this role where I don't argue with the judges, nor do I argue with the other team, but my role really in that particular round is to guide the judges through my submissions.
You know, in law school, students don't like to be asked for recitation, right? They don't, as much as possible, they avoid recitation. But in a moot court competition like JESSUP, if the judge does not ask you questions, something is wrong with your presentation, right? So you have to ask yourself, am I doing it right? How come there are no questions from the judges? In the last competition, and even before that, as you were there yourself, and you saw how judges interacted, asked probing questions, difficult questions. No? So basically, they were engaging with the debaters or the mooters, and you could feel and see the gush among the participants, right? They were not in agreement. They will whisper to each other as if being there as part of the competition themselves.
Last year's champion, the University of the Philippines, I especially look up to Ms. Chinzen Viernes. So every time I prepare my speech, I try to emulate her manner in how she conducts her speeches and how she answers questions.
I think definitely the level of the competition is increasing every year. As in, gumagaling talaga sila, which is good. But at the same time, it's keeping us on our toes na we can never be complacent. We are just as good as our last work. So kumbaga, yung championship win natin back in 2024 does not mean anything pagdating sa other problems. Kumbaga, we're dealing with a new problem, a new set of team members, a new set of competitors. So we always have to be on our toes.
Actually, our training regime is very strict, very comprehensive, and in fact, we've been preparing for several months now. And of course, that involves a variety on the regime of training. And as to how we would handle a competitive rounds and hot benches and judges, we trust on that training. We rely on what our coaches have always taught us, as well as just the strength and fortitude of our willingness to moot.
Because it requires discipline. I mean, you'll be reading things which don't have pictures, and you'd have to have patience, no? And the fact that you need to work with teammates, you can't do it alone. So it also shows teamwork. So you know that a mooter is a good mooter if he knows how to play by the rules and with a team. And those are the things we look for a lawyer. The skills I mentioned are lawyer skills, basically. That's why when we hire lawyers, we prefer mooters because we already know that they have the fundamentals. They have oral and written communication skills. They have legal research because you research international legal principles. And they are good in persuasion and they have critical thinking. These are essential lawyer skills. The materials that they read are actually legal materials. Some lawyers don't even know these topics, but these law students are more familiar with international legal concepts than most lawyers.
In the next episode, the competition heats up as more teams present the third issue of the 2025 JESSUP case. This is JESSUP 2025, the Philippine Rounds Journey.